Welcome to the Workers' Compensation Division training about the designation and responsibility of a paying agent. During this training, we're going to talk about how the Workers' Compensation Division designates a paying agent and what the designated agent's responsibilities are. We will also talk about how to request a designation from the director. This training will take about 15 minutes. This is a great training for insurance companies and their claims adjusters who process claims in Oregon. When two or more employers or their insurers find that there is an issue about which employer or insurer is responsible for a compensable claim, the parties must request a temporary designation of paying agent as required under Oregon Revised Statute, Chapter 656, Section 307. The temporary designation expedites benefits to injured workers while waiting for a hearing with the Workers' Compensation Board. This designation is necessary only for compensable claims with issues about responsibility. The Workers' Compensation Division's Benefit Consultation Unit, or BCU, will process the request and issue an order designating a temporary paying agent. The temporary paying agent is responsible for processing the claim and paying for benefits until relieved by an administrative law judge. The BCU makes its decision based on Oregon Administrative Rule, Chapter 436, Division 60, Rule 180. Typically, the designated paying agent is the insurer with the lowest cost of disability or the earliest claim filed for the compensable condition. The designated insurer must process the claim through claim closure as if it's an accepted claim. The temporary designation can be lifted by an administrative law judge through hearing, mediation, or settlement. When an employer and its insurer request that the director designate a paying agent, it is not an admission that the insurer is responsible for the compensable injury. It is solely an assertion that the injury is compensable against a subject Oregon employer. Anytime an insurer decides that a claim is compensable but is the responsibility of another subject Oregon employer, the insurer must request a designation of paying agent from the Workers' Compensation Division. An insurer's legal representative can make the request on its behalf. WCD often receives requests for designation from the injured worker's attorney. When these requests come in, we will notify the affected insurers of the request and inform them of their next steps to request designation so WCD can determine the temporary paying agent. The affected insurers should work together to try to determine which party is responsible. Working among themselves gives the insurers an opportunity to decide which is responsible without involving WCD or the director. When a responsibility issue is discovered, whether it's from the director's notice, notice from another insurer, or from an internal responsibility denial, the first step is to notify all other affected insurers of the responsibility issue. It's important that once each party is notified, the affected insurers expedite processing by immediately investigating the claim to decide if the claim is compensable and determine their responsibility. Once it's decided that the responsibility for an otherwise compensable injury cannot be determined, the affected insurers should request a designation of paying agent from the director. We will come back to how to make that request in a few moments. Now we'll discuss some examples to help better understand the 4 situations in which the paying agent may be unknown and a designation should be requested from the director. There are 4 responsibility issues that will result in the director ordering a temporary paying agent. These include determining the true employer, considering which insurer is responsible, figuring out which of a series of employers is responsible, and deciding who should pay in case of joint employment. The first situation is an issue about which employer is the true employer of an injured worker. In this example, John is injured while employed by a construction company that is working on a sportswear manufacturer's campus. The construction company and sportswear manufacturer each disagree on who the true employer is for the injured worker. Each believe the other is responsible. Because there is a disagreement on which employer is the true employer for the worker, the insurers should request a designation of paying agent. In this example, the employer has had multiple insurers over the years. Which insurer is responsible for the compensation? Joe has worked at Bravo Sawmill for 30 years. He recently filed a claim for hearing loss, which is an occupational disease. In the course of those 30 years, Bravo Sawmill has had 3 insurers. Insurer A covered them for the first 10 years, Insurer B covered them for the next 8 years, and they're currently covered by Insurer C. In this instance, there's no question that the occupational disease is related to work. However, each insurer believes the claim is not its responsibility. Because the insurers couldn't agree among themselves, they should request a designation of paying agent from the BCU. For the third responsibility issue, let's talk about Becky. She has worked in accounting for 16 years and is suffering from carpal tunnel syndrome due to keyboarding. Becky has worked for 3 different employers over the 16 years she's been typing. Each job may have contributed to the occupational disease, but the insurers are not able to determine which employer is responsible. This is an example of a claim in which 2 or more employers or their insurers could not make the determination of responsibility. In this instance, all affected insurers should request designation from the director. The fourth responsibility issue is determining which of 2 or more employers is responsible when there is joint employment. Business owner Will gets all of his employees through a worker leasing company. The contract states that the worker leasing company will provide workers' compensation insurance for their workers. Will hires an employee named Tim, but not through the worker leasing company. Tim gets injured, and the worker leasing company denies responsibility. The worker leasing company says that the business owner, Will, is responsible for the claim since the new employee was not hired through them. Will disagrees and thinks the worker leasing company should be responsible since it's responsible for the rest of his staff. This is a complicated situation, and because an agreement could not be made between Will and the worker leasing company's insurer, a request for designation of paying agent should be sent to WCD. Now that we understand some of the scenarios that would prompt an insurer to make a request for designation, we can talk more about the request requirements. When an insurer is requesting designation from WCD, the insurer must send the request in writing to the division, the worker, and the worker's attorney if they have one. The written request must list all of the compensable conditions and state that the claim is otherwise compensable and that responsibility is the only issue. The request should also list all of the claims for the worker related to the dispute, including employer and insurer information, the date of injury, and claim number. Finally, the request should confirm that relevant medical documents have been sent to the other insurance companies involved and that the worker is aware of the designation request. Oregon Administrative Rule, Chapter 436, Division 60, Rule 180, Section 6 describes what is required in a request for designation of a paying agent. If any information is missing, it can slow down the designation process for BCU. The director won't designate if compensability has not been determined on any of the involved claims. For example, if one of the involved insurers or employers state that the claim is not compensable or issue a compensability denial, the director cannot designate a paying agent. If an involved insurer opposes designation because it has not received a claim, the director won't be able to designate a paying agent. As an example, Insurer A requests a designation of a paying agent from WCD and copies the other insurers involved, Insurer B and Insurer C. Insurer C has not yet received a claim from the worker, so it cannot determine responsibility or compensability. Insurer C can respond to WCD, copying all other parties, stating that it opposes the designation. Because Insurer C has not received a claim or determined responsibility and compensability, the director won't designate. If the 60-day appeal period of a responsibility denial expired and no request for hearing has been received by the board, or no request for designation has been received by the director cannot designate a paying agent. For example, Lisa received a responsibility denial and has only 60 days from the date of the denial to appeal it with the Workers' Compensation Board. It has been 65 days and the Workers' Compensation Board has not received an appeal. Her appeal timeframe has expired, which means the denial is final and the director cannot designate a paying agent. Earlier in the training, we mentioned that WCD regularly gets requests for designation from the worker's attorney. When WCD receives requests from the worker or the worker's attorney instead of the insurer, the director will send a letter to all of the affected insurers. Once the insurer receives the notice, it must immediately process the request to determine compensability and responsibility and request designation of paying agent only if the insurers cannot determine responsibility on its own. Oregon Administrative Rule Chapter 436, Division 60, Rule 180, Section 6 requires the insurer to make the request for designation of a temporary paying agent. Once WCD receives a request for a temporary designation of a paying agent, the director will immediately investigate the request and determine if a designation is appropriate. The director may then send a letter demanding the affected insurers respond within 21 days with more information if WCD needs clarification on the intent of the denials or wage information to help identify the lowest costs. A response to this request for information is required under Oregon Administrative Rule, Chapter 436, Division 60, Rule 200. Failure to reply within 21 days with all required information may result in sanctions or civil penalties. When designating the paying agent, the director will first determine which insurer has the lowest compensation for the temporary total disability rate. If the rates of temporary total disability are the same, the director will then look next at the rate of permanent disability. For occupational disease claims, the rates of temporary total disability and permanent disability should all be equal. When rates of disability are equal, the director will designate the insurer with the earliest claim as the temporary paying agent. Remember, this is a temporary designation. The goal of this process is to expedite benefits to the injured worker while waiting for the determination of responsibility of the compensable injury. The designated insurer must process the claim through claim closure or until relieved by an administrative law judge, mediation, or arbitration. This means the designated insurer must take all of the same steps that it would for an accepted claim, including issuing a notice of acceptance and Form 1502 to the director. If, after designation, any of the insurers determine compensability may be an issue at hearing, or if there's a change in acceptance of a claim, the insurer must notify the director. When the director receives notification, BCU will order termination of any further benefits due from the original order designating a paying agent. Once a designation has been made or terminated, BCU is no longer part of the process. All parties will wait for the Workers' Compensation Board to make a determination. The designation of paying agent process can be confusing, but BCU is here to help. We are happy to answer any questions you have about this topic. If you have any questions about the designation and responsibility of a paying agent, call or email us for help. If you want more in-depth training on this topic, we're happy to meet with you via conference call, webinar, or in person. Thank you for watching this training.